and welcome to our webinar on India's new online gaming law, which came into effect only a few days ago, a couple of weeks ago rather, and where we will focus on some of the industry insights that we've been having a chance to, discuss since the law came in. The final rules have been issued. The law came into force on May 1st. And this is where we've had some time to, gather stakeholder questions, gather interpretation questions, gather points of confusion and overall curiosity in the industry and, what next. A lot of you all are still trickling in, but I'll take this opportunity to, get started. And we have a star-studded panel, here today. If you could see a very diverse panel and truly, representative of the industry. First we have, to start with, hardly needs any introduction, Mr. Rakesh Maheshwari ji, who is, former senior director and group coordinator, cyber laws, cyber security and data governance at MeitY, and now he's an independent consultant and an expert on technology and gaming laws. We have Ms. Devuti Bakshi, who is a director at the e-gaming federation or EGF, and we will hear more from her about, what they are doing now. And we have Mr. Deepak Phillips, who has earlier been associated with Yes Bank, HSBC, and ING, and who is currently a regional business manager. Um, the southern region at AU Bank. And we also have Shashank Venkat, who is a senior member in our firm's technology and gaming law team. I'm Aaron, the moderator for the session. I lead the overall technology media practice at the firm. Been here over a decade, and it's great to have such a diverse panel with different views, sometimes conflicting and contrary views, but that's the whole point of the session. To listen to everybody and figure out what the industry can do now going forward. We are going to see everything from codes of practice being issued to maybe some engagement, on the policy side, some consultation if possible. But how really the industry will shape up right now. So just as 30 seconds of backdrop, for those for whom this may sound an entirely new concept. Towards the latter half of last year, almost overnight, we had a new ban which came in, right? What we call as the PROGA, which is essentially, the prohibition of online money games and the regulation of esports and online social games, something Shashank will take us through in, a quick overview of what this new regime is. And then it took many months, there were draft rules that came out in between. And now last month we had the final rules that were issued, and the law came into force on May 1st. Prior to this, the Indian gaming industry was valued at about $6 billion. Many operators shut shop on, what we typically call as RMGs. Many have pivoted to social gaming, educational gaming, pivoted to content creation, streaming, other jurisdictions as well. So the entire RMG market has, sort of, crippled, and many operators have pivoted. It was an industry that also employed more than 200,000 people. Of course, again, now there are new opportunities in esports and social games, that we will see. But I'd with this context in mind, the whole point is to dissect, now that we have the whole legal regime in place, the rules, we have the online gaming authority which has been set up, and various processes are in motion. It's good to hear from the panel, where we stand, what is allowed, what's not allowed, what are operators doing, what can they do to shape the process going forward, right? And Shashank, this is where I'll invite you to maybe set the tone on, what are the classifications of games now, what is really banned, what is permitted, going forward, right? And what is the legal framework within which operators can, operate going forward. And then we will move on to some of the practical industry, expert opinions from the panel. So Shashank, please go ahead.
Thanks, Aaron. I think that before we get into the crux and the detail of the law, I think it's important to address the applicability at the first instance, right? This law is applicable to offering of online games, whether it be from within India but also if these games are offered from outside of India as well. So the law does have extraterritorial applicability, right? And I think given that context, now we can go into what the law really gives us. Fundamentally, the law classifies all of these online games into three buckets, right? The first being online money games. This is where a user is depositing money in the expectation of winning a return. Here, it's important to highlight that the definition of online money game is fairly expansive, right? It also includes situations where people are purchasing in-game tokens or assets and then further using that within the game ecosystem to wager these in-game tokens and assets. And these would also fall under the definition of an online money game. Here, the restriction is not just on offering these online money games, right? It's also on, there's obligations on banks and financial institutions to ensure that they don't facilitate any transactions towards such online money games, effectively making them the gatekeepers of the new law. In addition to this, even advertising and promotion of any online money games are also restricted under the new law, and breaching any of the above, that is offering, facilitating, advertising, etc., will lead to penalties under the act. And the penalties broadly range from around 50 lakhs INR to around 2 crores of INR, depending on the nature of the offense, whether it's the first or a subsequent offense. And yeah, so that's broadly on the penalty side of it, right? So the next category of games that we're dealing with is esports. Now, esports have to meet a very specific set of criteria, right, before they can be offered in the Indian market. One, have to be offered as a part of a multi-sport event. It has to be a multiplayer format. The outcomes of these esports have to be determined solely based on skill, mental agility, and dexterity of the participants, etc. So it becomes like incredibly important for them to meet these criteria first. Interestingly enough, the esports format allows for the money in and the money out as well, insofar as the money in is in the nature of a participation fee, and the money out is in the nature of performance-based prizes, right? And here we come to the most crucial factor for something to be offered as an esport, which is that it has to be registered by the Online Gaming Authority, and we'll of course discuss the Online Gaming Authority in detail shortly. But prior to such registration, it has to be recognized under the National Sports Governance Act. And this is primarily the bottleneck that the industry is facing currently, because there's a lack of clarity on how this recognition of esports is going to happen. So while the letter of the law does allow two categories of games, right, to be offered, which is esports and online social games, until there is clarity on how this recognition of esports is going to happen, the operator should be limited to offering online social games. Now, again, a brilliant segue into our third category of games, right, which is online social games. It's kind of like a residual bucket, right? So if a game doesn't fall under the definition of an online money game, and the operator does not want to offer this game possibly as an esport, they can offer this as an online social game. Online social games are games that are offered merely for entertainment, recreation, skill development, etc. And even these games are permitted to have a money in element, right? Wherein if this money in is in the nature of a subscription fee or a one-time access fee, this is permitted insofar as there is no expectation of winning that is coming from the payment of such fees, right? So these are the three classifications of online games. The second thing that the law gives us is the establishment of a body, right? The Online Gaming Authority of India. They are basically a body which is attached to MeitY, and they are responsible for the administration and implementation of the new law. The composition is basically people, representatives from various ministries, right? It has representatives from the Ministry of Youth Affairs and Sports, the Ministry of Law and Justice, the Ministry of Finance, and the Ministry of Information and Broadcasting as well. Their functions are fairly broad, and these basically include issuing guidelines on how online games should be offered in India. In addition to this, they'll be responsible to impose penalties, impose directions on people who are breaching the law. They will also be, of course, be responsible for determining and registering online games, right? And I think this is a significant part of the law, which we're just going to get into right after this. So the difference between determination and registration, right? So determination is basically the process by which the Online Gaming Authority is going to evaluate an online game and determine whether it qualifies under the definition of online money game, right? So this is triggered in three instances. The first instance is, of course, esports are mandatorily required to be determined. The second instance is that the central government may notify a particular online game or a category of online games that necessarily need to be determined. The third instance is where the online gaming authority or the central government suo moto can, look at the industry, see that there's a particular game being offered. If they're of the view that it could potentially be an online money game, they could direct such operator to have this online game determined by the online gaming authority. So what is the online gaming authority really looking at when they're determining a game, right? They're looking at the revenue model broadly. It's going to be the money in and the money out element. So for example, if there is a money in element, they're going to determine whether it's in the nature of a participation fee as it's permitted for esports, or if it's in the nature of a subscription fee or a one-time fee, which is of course permitted for online social games, or whether this is actually a deposit in the expectation of winning something, because this could potentially tip the scales that an online game could become an online money game. In addition to these factors, they will also take a look at potentially in-game assets, tokens, NFTs, and other elements that the game may have, right? And they may see whether these can be traded outside the game ecosystem for any fiat currency. These elements being present within these games will also tip the scales that these online games could be considered to be online money games. Once a game undergoes determination by the online gaming authority, there will usually be a determination order which is issued by the authority. In the instance where they determine such games to be an online money game, they may proceed with the inquiries and the penalties under the Act for offering such games. In the event it's determined that they are not an online money game, for esports, of course, it will proceed for the registration process, which we'll discuss shortly. But for online social games, they may be offered if the government hasn't specifically requested for these games to be registered, or then they may also proceed for registration if the government is of the view that they need to be registered. Now, these determination orders will be valid until there's going to be any sort of change in the revenue model or the payment structure which is being adopted for these particular games. So insofar as there is no change in this, the determination order is not for any sort of fixed tenure, but it will continue to apply until there's a change in the revenue model for such games. Now we come to the registration, right? Registration has a slightly broader ambit under the online gaming law. This is because the basically when the government notifies, so the first set of games that will necessarily need to be registered are esports, of course. But with respect to the online social games, the government considers like as something that needs to be registered, they're going to be taking in various factors, right? And this is beyond just the money in and the money out element. So, for example, if the game poses some sort of risk to the users, the scale of transactions that are happening on the platform, and in certain instances, there could also be instances where the operators are operating from a particular country, and the central government may possibly need that all social games which are being offered from such countries may need to go through the registration process, right? So this is broadly the distinction between determination and registration. So as said before, esports will necessarily need to be determined and registered. Online social games may need to be determined and or registered depending on the central government notifications that follow. So finally, we come to making an application, right? So this application is going to be made through the website of the online gaming authority. So whenever a game has to be registered or determined, the process is going to be through the online gaming authority's website. And when you're making this application, you're going to be submitting a lot of details, including the nature of the game, the proposed description of the game, and the proposed categorization as to how you want to offer the game, etc. In addition to this, a new element that's been introduced in the new gaming law is the inclusion of the user safety features, which I think is going to be detailed a lot further in our discussions today as well. Finally, there's a lot of additional compliance requirements that have also been placed on gaming operators, right? So these, for example, now gaming operators have to set up a grievance redressal mechanism where users can possibly report any grievances they have with respect to the online game. In addition to this, there's going to be additional requirements like designation of a point of contact and the qualifications of this person. And also, there's possibly going to be further clarity on retention of storage data within India, and we'll have to read these requirements with the Digital Personal Data Protection Act as well. Specifically for banks and financial institutions, there's possibly going to be guidelines on how they should be verifying certificates of registration, certificates of determination, etc. And there's also going to be instances where the central government, if they're of the view, or the online gaming authority, if they're of the view that there's a particular game that's an online money game, they may also direct such banks to freeze transactions, suspend transactions, etc. And banks have to be cognizant and comply with these directions. But this is just, again, a very, very broad overview of the law. And I'll give it back to Aaron, who's going to like take you through the questions in a lot more detail.
Thanks, Shashank. That was a very, exhaustive but crisp capsule, of what the new law, tells us, what is prohibited, what is allowed, and how maybe, how it would be allowed. I think without um, without further ado, let's get into some of the discussions on the law, right? And this is where our panel of experts, comes in. So we have a definition, as Shashank already explained, of an online money game, right? And this is where I'd like to call, Mr. Maheshwari on really what is gameplay, right? What factors is the government really looking at when determining these online games as online money games, or traditionally called real money games, or RMG, right? Obviously, they talk about wagering, they talk about those kind of things, but what kind of games, what factors are they looking at, and does it cover all the games? So are even like your scratch cards, loot boxes, spin the wheel, these kind of things on fintech apps, e-commerce apps, those kind of things, are they also intended to be covered? How far does this really spread across, Mr. Maheshwari?
Yeah, so thank you. First of all, thanks a lot. Uh, I just directly come to the response to your question. See, the Act has very categorically defined as to what online gaming is, what online money gaming is, e-sports, and social gaming is. So once these definitions have been clearly laid out, the rules per se have gone beyond and have conveyed as to how exactly the process of determination will actually work. As was conveyed by Shashank, that as far as the determination is concerned, it shall be done only in respect of uh, esports and also in respect of certain social games which on a suo motu basis or based on the volume, based on the money transactions that they happen, or maybe wherever complaints are there, or maybe additional guidelines primarily arising of the harms, potential harms that those gaming applications and gaming service providers shall also be evaluated in respect of as to in which bucket they actually fall. And that's how it will actually go. The website of the ministry, of the online gaming authority should come up in a short time, in a near future. But the factors continue to be the same as to what is the way the money is being taken, if at all it is being taken, in what way maybe the money is going to be disbursed, once again, if at all it is going to be disbursed, or what will be the organization structure. And in case of esports, of course, there are other guidelines as to, because it has to be vetted through, and it has to be in a way recognized by the esports authority under the Ministry of Youth and Sports Authority. Having said so, I believe to begin with, the requirements are very clear from the definitions and from the way the applications will be asked for. Now, as far as certain aspects which you have mentioned, particularly if they are happening, say, for example, in fintech industry or in e-commerce industry, let's say scratch boxes, scratch cards, or spin wheels, or maybe some sort of a discount coupons which are being offered. So they are, in my view, first of all, there are regulators in those respective areas, and the law very categorically says that the requirements of this authority is not going to be in so wherever the law exists, normally that law and that regulator will take care. But also, I would also like to mention that these are more of marketing aspects, and they are not exactly the games. The primary function of those apps are completely different. And such marketing aspects, such advertisements, such promotional activities are actually not part of the games, and hence they can and they should continue to coexist the way they are existing today. It's only in respect of loot boxes, maybe the way they are going to be there. Once again, we will have to look into the definitions, that if there is a money in, or there is a clear expectation of maybe a winning, that the definitions will have to be seen. And in case it happens to be an online money game, it continues to be prohibited. Yeah, I'm done.
No, absolutely. So Mr. Maheshwari, so it's essentially the key is there money in? Is there a wagering element? Is there depositing money or stakes with an expectation of a winning? And the actual presence of a game play or an activity may be ancillary or secondary, right? On whether it is an actual game in the true sense or whether it is a sort of a spin the wheel, sort of a scratch the card, concept, right? It's the regulator will look at it as a whole now going forward, because even if you see the objectives of the act, the whole point was to curb the social issues, right? Around a certain addictiveness of, betting, gambling, wagering, and all of that, right? So these things will be looked at as a whole. Of course, there is earlier jurisprudence under the erstwhile, state-wise laws on, what is a gameplay and all of that. We will have to wait and see the validity and how those laws will continue now to interplay with this new centralized, online gaming act. But that's very helpful. And you spoke about, esports, for instance, and this is where we'll segue more specifically into esports. As we know, but now, and I'll invite Devuti to come in here. Um, the esports need to be registered with the authority to be offered. That we know for sure. As part of that, they also need to be recognized. Um, Currently, there is no scope, there is no framework for such recognition. There's not much clarity on the process for registration or other determination of such esports. But this is the industry really that the government wants to promote. They have specifically allowed it. They're allowing even participation fees. They're allowing performance-based winnings. They're promoting these kind of tournaments, multi-sport events. This is where there's a real business opportunity, right, for offshore and domestic operators. So where are we really going with this, in terms of actually now next steps in terms of developing that framework and, really greenlighting esports in the country, Devuti?
Thanks, Aaron, for that, for this very interesting question. So yes, the government has shown its intent to promote this particular vertical, but just merely expressing your intent is not enough. We don't have, like you rightly pointed out, and as Shashank also mentioned in his intro, we don't have a plan in place. We don't have a plan for next 6 months. We don't know what is the, how do we go about this? Like you rightly mentioned, there is a whole calendar of activities which includes multi-sport competitive events, and these multi-sport competitive events happen every month, or like I mentioned, there is a whole calendar. Now, in the absence of, just a quick recap, to continue to offer these multi-sport competitive events, you need to have a recognition as esports, because the multi-sport competitive events include money in and money out. Like you mentioned, the prizes that are given out and the fixed fee that you have to pay to enter these events. So when money in and money out is involved, you have to get recognized as esports. To get recognized as esports, you have to approach the Ministry of Youth Affairs and Sports, and you have to be recognized under the National Sports Governance Act 2025. However, the National Sports Governance Act 2025 right now does not include any framework or definition of how it is going to recognize you. The rules have prescribed broadly a definition of what an esport should be. There are 5-6 criteria that have to be met. But the most important criteria is that you first be recognized under NSGA 2025. And the NSGA 2025 right now is silent. So therefore, the step of recognizing and registration is right now null and void. If you are a multi-sport competitive event organizer and you have events coming up on your calendar, you really are in a jeopardy. If we try and seek clarity from Ministry of Youth Affairs and Sports, we've not been given any response from them on what those timelines are. How are they planning and when are they planning, more importantly, to give the industry this clarity? Because everybody's operations are going to be on hold. Without this recognition, if you continue to go ahead with your sporting event, which is already calendarized, you stand the chance of being labeled as an online money game. And all of those punitive actions which have been, and the penalties which have been prescribed in the rules will apply to you. So what do you do? In this scenario, where the e-sport is really the bottleneck or the roadblock, while the intent is there, but there is no implementation plan in place, there is no clarity being given out to the industry on what the industry can do, how should it proceed with its events, or how should it go about its normal activities. What should the players do? Should the players also be on hold? Should the tournament organizers also be on hold? So, in such a scenario, I really urge all of the stakeholders involved, the player community, the tournament organizers, the other operators of esports games and events, um, to please come together and jointly approach the government for clarity, for timeline of that clarity, and to probably also allow a transition window. So, in the absence of an immediate clarity where all events are on a standstill, kindly allow us a transition window to continue to organize those events until the time such clarity emerges. And this is really a call to action for all stakeholders involved with esports to please come together, contact any of the associations which are active and engaging with the government. We are definitely engaging with the Ministry of Electronics and IT on this issue, proactively engaging with them to get clarity on this particular issue. So anybody who is willing to join us, join forces, let us all collaboratively work together and approach both MeitY, both the Online Gaming Authority of India, as and when it gets operationalized. We right now don't have any timeline on when the OGI will be operationalized either. But anyway, whenever OGI is up and running, let us approach OGI, let us approach the Youth Affairs and Sports, let us urge them to probably start a board, a dedicated board, which will deal with esports applications so that we can fast track that process and those applications are not stuck for a very long time, further delaying this entire calendar of events that I was referring to. So let us all unite our efforts and jointly make the Ministry of Youth Affairs and Sports a little bit more proactive and accountable for giving us clarity on timelines on when it plans to get the framework operationalized under the NSGA 2025 for recognizing esports. Aaron.
Absolutely, Revati. Thank you. It's very important to play a key role, in shaping the new framework. So I'm sure you'll have a lot of engagement with the industry, a lot of representation, and we're happy to help, put forth some of those, representations and help, shape the framework and the processes if needed. But that's very helpful for you, to steer the industry, towards more clarity and actual business opportunity to fructify, right? So extremely important. We'll segue now into, the banking fintech aspect of it. And, the law is prescriptive in terms of um, operators, being, banks, financial institutions, fintechs facilitating transactions, for various forms of games that we've been talking about. And the law really makes banks gatekeepers and requires them, to exercise due diligence, checks and balances, when onboarding gaming operators, right, for permissible games, which are social games and, registered esports. So I'll call upon, Deepak here, um, from a banker's perspective. What really changes, will banks now implement, to meet their diligence requirements, to one, for instance, to verify any certificates of registration. But, how will that whole, process change in terms of facilitating the gaming products?
Yeah, sure. Pretty relevant question, Aaron. Thanks for that, and thanks to the Nishith Desai team. From a banking perspective, and to answer your question in a little more detail, so banks anyway have control mechanisms in place, industry-wise, especially with regard to online gaming. As of now, I think for the bank, the control mechanism would be one, to know your customer, two, to know your customer's customer. So, for example, in know your customer, the regulation also has with regard to age restrictions, even for certain permissible games, and even for esports registration with OGAI, etc. So, a bank would take cognizance of those kind of points, but on a broader picture, know your customer in terms of one, their ability and the location from where the initiation happens, and also knowing your customer's customer. So one is knowing the company, and two, also the underlying transactions that happen. A simple example being the country of origin. Where is the origination happening? So banks would place control mechanisms, though not easy to know the place where the origination is happening, whether it's within the shores of the country or outside. Also, understanding what is important is the revenue model. Unlike historical RMGs, here you would have very less of payouts, and it would be, in terms of value, very less value pay-ins as well. Whether it is the bank directly extending their APIs and Rails, integrating, or otherwise as well with their support at TSP, to get these kind of setups done. So those are again checks that the banks would have. Clearly, there are already flags in place for regular banking transactions. Those would be tweaked specifically for this industry to get those flags in. So that would be also important. Also, in terms of identifying the source from where the funds are getting generated. So, large money coming in, which is not in line with, the usual turnover of the corporate, for example. So those are again things that would be monitored. So all in all, in terms of whether it's a pay-in transaction or a payout transaction, to ensure that, we identify the place where the pain is originating, or the country to where the payout is going. All those control mechanisms, and like you rightly said, Aaron, in terms of bank being a gatekeeper, not only a gatekeeper, I think that's the most critical point. Can become a choke point, and also be a point where the transactions are permitted. So it's a very, very important link. I think in the overall industry, bank would play a very, very important role as a gatekeeper, as a point of flagging of transactions to OGI. So those would be important roles, and those are the things that need to be kept in mind for any kind of transaction there.
Oh, absolutely. Very helpful, Deepak. Essentially, the whole revenue model, money in and if so, money out in terms of innings or whatever would come under scrutiny, right? And would be studied by the banks. And I'm sure there would be representations that would be taken. There would be people within the banks to maybe study the model. Maybe there would be, law firm opinions sought, or, to clarify or to demonstrate that the model is compliant. So we definitely see this evolving. But yeah, for sure, as gatekeepers, you all will be um, definitely studying the models, and the entire revenue model and payment flow of the gaming merchants that you're operating. So very interesting to know. I'll come back to you a little later in the session, Deepak. I'll go to back to Mr. Maheshwari now. When we look at really who does the law apply to, Mr. Maheshwari, the law applies to overall. There's a definition of online game service provider, right? And that service provider is very broad. Anybody who facilitates, offers, makes available, those kind of things. It's not literally just a publisher or an operator of the game, right? So the question is, what kind of platforms, what kind of entities does MeitY really want to, bring within the scope of the law, apply to app stores? Will it apply to gaming platforms, console platforms, operating systems, platforms that host games, ecosystems, those kind of things, or just operators? Because not only the prohibitions and the penalizing provisions, but also some of the compliances, like data retention, data storage, point of contact, some of those things. So I'd like to bring you in here, but just before that, just a call out to everybody. We've been receiving some comments, and we'll take your comments on the session itself. We may not respond individually to you, but we will definitely take it up. I can see Priyal's question, so we are noting it down, and we will take it up in the panel session. But please keep the questions flowing in the chat box, and we'll take it up during the course of the panel. But just coming back to my question, over to you, Mr. Maheshwari.
Yeah. So basically, we once again look at the two definitions. One is that of the online gaming service provider, which I'll come. But as far as registration and determination is concerned, particularly in respect of esports, there will be two combinations, which will have to be seen. That's my understanding. One, the game itself. Now, the game, if it is offered just like that, it actually can turn out to be a social game as well. So, and then along with the game, the gaming operator comes into picture, and that's where the online gaming service provider and its definition becomes very important. Now, as per the rules, it says that online gaming service provider means any person who alone or jointly offers, operates, organizes, manages, or makes available one or more online games. And as you have rightly conveyed, should it mean the frontline operator which is providing the games directly, or all those intermediaries and facilitators who are in a way part of the value chain? My first understanding is that it is primarily those front-end people, front-end gaming service providers, who are and who should be falling in this definition of online gaming service provider. It is normally, I can just take the example, let's say financial intermediary, or let's say an app store, because they are not dedicatedly meant for such gaming applications. And therefore, in my own understanding, they are not intended to be the online gaming service provider. However, if there is any dedicated service, if there is any dedicated OS, if there is any dedicated maybe app store which only provides such online games, then that should also be considered as, to be inclusive of, or to be part of, or to be covered by this definition of online gaming service provider. Having said this, does it really mean that the obligations are only in respect of this service provider, and what about those intermediaries, what about those app stores? It is expected that maybe as part of IT rules, maybe as part of the other powers that the authority has got, that the directions as may be required to be followed by the other intermediaries, which are in a way supporting the overall gaming ecosystem, shall be issued directions, SOPs, code of conduct, which they will have to adhere to. So per se, they are not within the scope unless they are dedicatedly meant for provisioning of such services. But in any case, they have to abide by the directions which the online gaming authority or the central government, wherever, such things are there, and the rules are very categorical, and the act is also very categorical as to what are the powers or delineation of powers between the central government and the OGI. I think that's how the system will work.
Right, Mr. Maheshwari. Maybe we can take Priyal's question while we still have you, right? Since we're
Yeah.
talking about operators, do software providers, to operators of online money games, can they be penalized under the law?
Okay. Let's take a particular software, and I typically take something, I mean, which is, let's say, is likely to be an online money game.
Yeah.
Let's say Teen Patti. Now, Teen Patti in itself, if there is no money in, there is no money out, it can be just a recreational entertainment kind of a game. Therefore, from a developer perspective, there is nothing wrong with this development, and it's only the gaming service provider, the operator, which decides the format, which decides the fee, which decides the entry fee, I mean the winning, if at all, if it is there. So the software service provider in this case actually shall not and should not be penalized unless the built-in features forces you to charge or to give the payout. So in general, what the question which has been put to me is that in general, the software solution provider will not get into the, I mean, may not be the actual culprit. It is the person who is the operator who is actually deciding the format of the game, the revenue model, the kind of revenue model that they have thought around it, the kind of safety features that they will have to build. So prima facie it is operator, but in respect of, for example, safety features, in respect of metadata which gets collected, I mean, or which should be generated, there will be certain obligations to the gaming application as well.
Absolutely.
Yeah.
Absolutely. And I think it's no, it's not a one size fits all. Even software providers, for them to be penalized, it has to be even legally under the act, it has to be shown that there is some intent and knowledge, right, for them to aid, abet, induce, facilitate, or support or engage in offering of the online money game, right? If it is just a B2B service without knowing what the end product is, maybe you can demonstrate that there is no knowledge and intent, right? And you don't fall under the penalizing provision. So the overall arrangement will have to be looked at between service providers and operators. But thank you for those inputs,
Yeah,
Mr. Maheshwari.
I'll also like to add, maybe in respect of security, in respect of privacy, because the operator will also be collecting personal data, the software developer will also be, the app developer will also be collecting the personal data. To that an extent, whatever are the requirements conveyed by the authority or whatever are the requirements as stated in the other applicable laws will continue to be complied with both of them.
Sure. Very helpful. There are some more questions flowing in. Maybe the panel, we can take it up one by one, but let's move on. Shashank, I'll bring you in for just maybe half a minute here, right? Since we're talking about all role of other players in the ecosystem, just tell us about advertising here and what are the constraints or the impact on advertising in the gaming industry, please.
Yeah. So unlike banks and payment systems, which are, expecting further guidelines and guidance from the Online Gaming Authority, advertisers have a prescriptive law that says you should not be advertising or promoting any of these online money games, right? So at the advertiser's end, they should ideally be doing some due diligence to make sure they're not, advertising any online money games where there's like a little bit of a lack of certainty. What they can do is possibly get a legal opinion on this matter to make sure that they are protected. Contractually speaking, they can seek like representation warranties, indemnities, and all of the contracts with these online game service providers to ensure there's no liability that comes directly on them. And of
Yeah.
course, they always have the website of the Online Gaming Authority to see what games are permitted, what is prohibited, and what they can advertise. So that's how
So
they should
what we
go.
are taking away is that there is still a form of due diligence even by advertisers, right?
Correct. Yes.
Because there's a penalizing provision for them as well. So even they need to do some amount of due diligence, which is anyway there under existing consumer laws and influencer guidelines, those kind of things, right? We'll move on. We still have a couple of points to cover, and we're looking into the Q&A, but just being conscious of the flow, the time as well. We'll bring in Deepak here again. for a couple of minutes. Specifically, Deepak, with respect to foreign operators, right? The law has extraterritorial applicability. Um, it applies to foreign operators, where, can be sports, even permitted online social games, registered or at least determined, or otherwise permissible as well, right? They could operate legally, right, from outside India. Historically, our foreign exchange control laws have not been the clearest. There have been restrictions on users in India transacting, with foreign platforms for gaming, gambling, those kind of activities. But now, since we have this dedicated law, and some of the models being offered by offshore operators may be legally permissible under this new law, does it mean that the foreign transactions, from Indian users to offshore operators would be legal? Will banks be fine to support it, or will they take their own, course of direction?
So, Aaron, again, a very good question. I think so. With the backdrop of this additional regulation that's come in, I think for a bank, they still need to take a holistic view of the applicability from a FAMA perspective. So, specifically on the cross-border transaction, like I said, the regulations around the countries through which the transaction happened or the currencies in which the bank can deal in, apart from even the underlying nature of transaction. So this certainly gives additional comfort, but that doesn't mean that the banks will be able to utilize this regulation and start doing transactions which were erstwhile not not being taken up. So this does give additional comfort, but still for any financial institution to take up a cross-border transactions, regulations of the Reserve Bank of India and FEMA would still apply. So giving additional comfort, yes, this would still remain. Plus, probably as a financial institution, we deal in documents, not actually looking at the underlying, goods or services that are getting through. So, support from taking independent views, opinions, or certifications from law firms or otherwise, as guided, would also be present. So, yes, so these are the control mechanisms for cross-border transactions. So, the nature of account from where the funds are coming, whether it's an escrow account, a fiduciary account from where the funds are getting flown, paid out, or whether it's from the corporate's account. Those are again the things that would be looked at.
No, great. That's great to know. I'll just keep you for one quick follow-up question. But what the takeaway here is that you could even have legally permissible games offered by offshore operators to users in India, right? But under the foreign exchange control regulations, which will continue to apply, independent set, and there are certain current account rules and restrictions. So depending on each bank's policy and appetite and approach, they may or may not permit the transactions, right? And this law is a separate law. It will continue to operate. So really, what we're taking here is that it's also up to each bank to continue to monitor why the money is going out, who are the foreign platforms, for which Indian users are using their credit cards, for instance, and if needed to monitor, if needed to suspend for suspicious transactions. I'm sure there's a PMLA, anti-money laundering aspect to it as well. So those kind of transactions will continue to be monitored, and if necessary, we could see blocking as well. Is that generally the course, Deepak?
Yeah, absolutely. So like I said, so while this gives additional comfort for a financial institution to take up the transaction, but the control mechanism of cross border would still remain, and banks would then look at the original and destination of the money, and also the required checks we do in terms of in country risk checks, individual restrictions on specific lists, as well as specific transactions. Those would still remain.
Great. Very helpful. I will um, move forward maybe to the last planned segment of the session. Thanks, Deepak. I'll call in Devuti again. And in the meantime, I will take one quick question. I know there are a few pending questions which we will come to. Chris is asking what money generation model is allowed besides ad revenue. So for esports, there is allowed a fee to participate. A participation fee or an administrative fee is allowed to be collected, And even for social games, there is a subscription or an access fee that's also allowed to be taken from users. So it's not that there cannot be money in. There cannot be money in with an expectation um, of a winning or akin to a wager, but certainly there can be participation, subscription, access, administrative fees that are taken for esports, and social gaming. So I hope that clarifies Chris's question. Devuti is on screen, and Devuti, so we touched upon user safety features. Now, user safety features, you're welcome, Chris. User safety features is a term very subtly used, very just 3 or 4 times in the whole document, but it has a very big impact. It goes into age gating, age verification, parental controls, all of that. Tell us what really will user safety features uh, sort of entail? Will we expect to see codes of practice being issued by the authority for child-focused, games? And also, we are seeing that when doing a determination, the authority will look at user safety features. So it's up to the operator to implement user safety features, which will then be taken into consideration actually doing a determination or even a registration. So really, how are we going to see this develop? What is the tech as well as the business impact on operators as well? And how do you see this evolving, Devuti?
I'm very glad that you're asking me this question, and this is really the most pertinent question to ask in today's time. The very fundamental reason why these rules were brought about was to ensure user safety. However, ironically, user safety seems to be the only component which has been thrown under the bus. The reason I say this is this. The authority is saying that when you apply for registration to OGAI, you should describe what user safety features you are implementing on your gaming platform. At the same time, they themselves have acknowledged that user safety features, they pan across technical, procedural, operational, behavioral, and system related safeguards, which are safety by design features. When the ministry itself is acknowledging that there are so many different kinds of user safety features which are required and which are essential, particularly for child safety on a gaming platform, yet there is absolutely, this is a very loose ended compliance requirement, so to speak, because it works on self declaration. When you are applying as part of your application, you are listing down what are you doing. But the code of practice that is supposedly going to come as and when it comes, and the code of practice may or may not prescribe a list of best practices user safety features which are globally used across leading gaming platforms. What is that checklist? How many of those user safety features are you required to implement? You can't just be implementing one user safety feature which is a very frivolous in nature and then checking the box. That should not happen. You can't take this user safety feature as just merely a guideline. And I say this from experience. I am from the e-gaming federation. The e-gaming federation, as many of us know in this gaming ecosystem, was the only industry association to introduce a code of conduct back in 2018. And not only the code of, and our code of conduct, by the way, featured a whole list of fair play standards. Our code of conduct was only containing fair play standards, which itself is a very vast field to cover. There are so many fair play standards that can be included in a gameplay. So since 2018, not only did we introduce the code of conduct, we have also got a third party to audit our gaming operators on compliance. Because from experience, I am saying that it is not easy. It is not easy to implement these user safety features. If you're talking about system related safeguards, there is a lot of re-engineering that is needed. There is a lot of time and other resources, commitment which is needed to implement these features. Similarly, for technical, for procedural, for operational. And funnily enough, the rules have also indicated what these kind of user safety features should look like you mentioned: age verification, parental controls, time restrictions, counseling support, user in-game user reporting tools, and associated grievance mechanism, fair play tools. Is this a joke? This entire scope of work, age verification user features themselves are so vast and exhaustive. Parental control features are such an exhaustive field to implement. Without giving any specific checklist or without giving any specific compliance direction, how will anybody ensure that a particular gaming platform is actually implementing these features, that it is self-declaring in its application? Who is going to ensure implementation? It is so therefore I use this platform today to urge the ministry that whenever, as and when they come up with directions, orders, guidelines, or the code of practice, to please ensure that that code of practice is giving a thorough checklist of what all user features are really essential and cannot be compromised on, and what user safety features are good to have or add-ons. And in addition to this checklist, they should also give a threshold that you have to meet all the essential ones and you can voluntarily meet the add-on ones. And then they should also prescribe audits, independent third-party audits, to ensure that that operator is actually implementing these features. I also want to leave our audience with a very fun fact. And the fun fact is this, that the erstwhile online money gaming industry had voluntarily come up with code of ethics. In 2023, the three leading skill gaming industry bodies had jointly adopted a voluntary code of ethics, along with there were four associations that jointly adopted it in December 2023. Again, in March 2025, the three leading skill bodies mandated this code of ethics on its 100 plus gaming operators, along with a mandatory audit of all of those 100 operators. And there was a minimum score which was shared with everybody as a threshold for passing the audit, that you need to implement these essential features at least. Age verification itself is a feature that many operators can bypass by merely saying that, oh, we are using KYC as an age verification feature, but it is not working out, or KYC mismatch or whatever. We all know that there are so many go-arounds in even KYC as an age gating tool. And I also want to share that, as we all may be aware, child safety features is really the spotlight globally right now. Several gaming platforms that deal with children are being pressurized to take proactive steps in terms of parental controls, in terms of content moderation, in terms of user filing its complaint and what action have you taken on the complaint that has been filed by a user, etc. There is a global pressure by several governments to ensure that these gaming platforms are actually implementing these user safety features and not just getting away by declaring that, okay, we have these system designs, etc., etc. So I feel that the ministry here has really opened up a Pandora's box. User safety features, especially with a focus on children's safety, is a whole lot of work that needs to be done and takes a lot of time and other resources commitment for an operator to implement those and embed them in their safety by design. And therefore, without really holding anybody accountable and ensuring whether these user safety features are actually being implemented, it is just going to be an eyewash. Given the criticality and sensitivity of this topic globally as well right now, and how the spotlight is on child safety, I really hope that the ministry will come up with a good code of practice, including implementation and other thresholds to clear the application status. Otherwise, merely self-declaration at the time of application is not sufficient enough.
No, absolutely. Absolutely. In fact, we'll have to see how these user safety features, for instance, child verification and parental controls interlap, with the DPDP, India's new data protection law as well, coming into force of May of next year, right? Mukesh, can we have everyone here? Maybe we take the few Q&As pending. If anyone has any other Q&As, but we have a few pending, I thought I'll uh, put it up. Um, Trisha is asking, if we as a provider deal with gift vouchers, and for that the customer needs to purchase bid coins and make a bid to purchase gift vouchers. Whoever bids the higher gets the gift voucher. Please help us know if we fall under an OGSP. Very quickly, if 10, 20 seconds, if you just want to say, basically the short point is that you're giving gift vouchers, but you're making a person purchase coins to then get something else which they could then get gift voucher. I think we're seeing a lot of formats like this. Would anyone from the panel want to comment? Devuti or Mr. Maheshwari?
So I do believe maybe in respect of online gaming platforms, this may not work,
Yeah.
but in respect of other sites, because I did mention particularly say e-commerce, particularly maybe fintech apps, where you already have availability of regulators, guidelines, say for example on dark patterns and stuff like that. Maybe in the because of the advertising model, because of the way the whole commercial world moves, such things may be allowed, but definitely to me it appears not on online gaming platforms.
No, absolutely. I think we've seen some of these models for various clients, even if there's no direct deposit of money, but money is worth or other stakes, which directly or indirectly puts you in some contention to win something. That is the whole point, of OMG and what is being prohibited. But of course, each one will have to be looked at. Also, there is a consumer protection angle. If you all read the definition of unfair trade practice, these kind of things, whether it's to promote something, all of that. But yeah, a lot of these models may get caught as well. We'll have to see if it is structured as a participation or access fee or, within the realms of the law. But yeah, these models also may come under the online money game restriction. I will also just check. There was one more. What is the regulatory position regarding financial games or fin games related to the stock market, future predictions, investment-based gaming formats? Are such models permitted?
So once again, in respect of, let's say, any such market instruments, SEBI is already there as the regulator, number one. Now, if this prediction turns out to be sort of a wagering kind of thing, and which is where maybe evaluation may have to be there, may have to be done, then so if it falls within SEBI's domain, it's very much there, it's very much allowed, and there is a regulator to look into it. But if it is falling within the wagering and the online gaming space, I believe because of the involvement of the money, if there is an involvement of money, it will once again fall into the definition of online money game and hence prohibited.
Devuti, I know you unmuted. Please go ahead.
Yes, so I was going to say the same thing, that the PAROGA, the Act, the Promotion and Regulation of Online Gaming Act 2025, which came out in August last year, has explicitly banned any online platform facilitating wagers or bets on real world events, whether it can be election, sports, or whatever. So this has been explicitly stated in the Act itself. And therefore, any sort of prediction platforms are explicitly banned currently as under the PAROGA and the rules which have come out.
Yes. There's one more question. Would an app intended to promote physical fitness, where it is not really played online, fall within the rules if the participants are offered rewards based on how they perform, say a marathon? Would an app intended to promote physical fitness app, so it's that's the digital aspect, I guess, but it's to promote physical fitness, not really played online. So there's no gameplay online like how we spoke about earlier, Mr. Maheshwari. Participants are offered rewards based on how they perform. Let's say they perform 10K steps a day or run a marathon, but there are some winnings. The way I would look at it, and I would invite the panel to also add to this, is that if there is no money's worth or stakes being put in, if it's rewarding your steps or running a half or full marathon, I believe it would not really come into the concept of an OMG. But any differing views, please.
Yeah,
I,
first
I
of all, it may, sorry, please continue. I mean,
no, no, sir, please carry on.
no,
I'll
no.
go after.
First of all, this may itself not come within the purview of the act itself.
Exactly.
So that's point number one. And point number two, because per se there does not appear to be any component of wagering here. It's a milestone which is to be achieved. So even if it is, say, let's say, presented in such a form that it looks to be a gaming kind of an activity, even then, I believe that, I mean, once again, the revenue models have to be seen. If there is no difference in terms of whatever is being charged as the input fee, or maybe there is no fee at all, and such milestones are declared, then one, of course, whether it falls within the definition or not, two, or therefore within the purview of the act or not, two, I believe it should be allowed. And that's where maybe the Bhuttiji, if you can.
I agree with you, sir. Like we've already heard, sir, in the beginning of the webinar, gamification necessarily does not mean that you will be classified as OMG. You have to see where is in the gamification also, where is the money in coming out, how is the money going out,
Yes.
and that will itself determine whether that is allowed or not allowed. Let's be clear, the only thing that is not allowed is the online money game. And to be classified as online money game, you really have to understand the in and out movement. But at the same time, I don't think this physical activity promoting fitness app has any element of gamification. At least that is not clear in the question itself
Yeah.
to me. So what is that element of
Yeah.
gamification? Only then can we move forward on this question.
No, absolutely. There isn't on the app, it's more milestone performance. Like if you
Yeah.
walk 10K steps, or there's no actual game or gameplay, right? Which is what we discussed earlier. So there's a lack of that to be considered an online game in the first place. And then you will look at, also things like, is there any deposit of money or the stakes, which no. So these kind of models, I don't think these are the kind of models. In fact, it's a socially, it's a good app to have socially, right? To promote fitness and not spread or cause addiction to wagering, right? If you really look at the intent of the law in the statement of objects, right, and the preamble. So absolutely, these models need to be looked at holistically. The performers, okay, so the same, Jayashree saying if the performers receive cash rewards, again, Jayashree, I mean, again, same factors. If there's no particular online gameplay and there's nothing really being put in with the expectation of winning, then should be, clear. Um, I think that's about it. Just to add one point on the finance related games. Yes, SEBI does exercise control over these kind of markets under SEBI regulations in terms of derivatives, futures, commodities, stocks, and gamified versions of trading these such as items. You look at even erstwhile state-wise gaming laws, even they do largely they have provisions, in fact, that restrict prediction markets and contingency events, and putting money on it and those kind of things. So largely those kind of prediction platforms and investment-based gaming products are largely not allowed, not only under PROGA historically and under SEBI prohibitions. But yeah, I think that wraps up our Q&A. I know we have exceeded by 10 minutes. It's so nice, and I'm very pleased to see most of the audience still with us. So clearly, it's a good sign that we've kept it engaging and this has been of some use. But thank you everyone for attending. I'll take this opportunity to thank, the lovely panel that we had today. Mr. Deepak Phillips has left. He had another engagement, so he dropped off, but he provided very valuable inputs from a banker's perspective, vis-a-vis the gaming ecosystem. Ms. Devuti Bakshi, thank you. And speaking about EGF and all of what you all are doing and plan to do, and really the call to action and how to shape things, going forward. And Mr. Rakesh Maheshwari ji, thank you as well, as always, for your very thoughtful, insightful inputs on, government intentions, overall intent of the law, where things could go, industry trends, and just generally on the question and answers. And Shashank, important member of our technology gaming team, for a very lucid overview and spelling everything out in terms of the new law and, all that it prohibits and regulates. So thank you all. It's been a pleasure, hosting and moderating this session. Um, Please feel free to reach out to us for any follow-up questions. Read our article that was circulated along with the invite, and we'll see you at some of the upcoming, sessions in the industry generally or that we host. Thank you, everyone, and have a good rest of the day and take care. Thank you.